Hello, everyone. Welcome back to our short conversations about art law. We had a very brief general overview of what art law is and how it applies in our various jurisdictions. And I'd now like to move on to the artist and his or her rights and responsibilities under the law. And first, Kyle, I'd like to discuss areas in which the artist might come into conflict with the law. Now, historically, this has had to do with censorship because an artist has been seen to blaspheme or to violate laws of public decency and so on. So I wonder if you could talk a little bit about the artist's right of free expression.
Absolutely. Freedom of expression of the artist is obviously one of the kind of fundamental rights, which is indicative of a kind of free and thriving society. So it's something which the law desperately tries to encourage, but at the same time, it's something which the law has had to balance, particularly in the past. Basically, taking an approach which balances, on the one hand, that very important idea of freedom of expression against the really need to protect the public from displays of objects which are considered to be clearly obscene. And that balancing act has been done in several ways. There are a couple of guiding principles here currently in force in the UK, although it has to be said that in the case of both of these statutes, they've been so significantly undermined that it is very difficult these days to prove that any artistic work certainly violates the obscenity laws. The first of those statutes is the Obscene Publications Act of 1959. The second, the Indecent Displays Control Act of 1981. As I say, both of those have been severely limited in their scope to prevent the display of art. But technically, in both cases, pleading that a work is artistic is certainly not a defense in itself. So, firstly, under the Obscene Publications Act, it was tested very famously in a claim which was brought against Penguin, the publishers of D.H. Lawrence's Lady Chatterley's Lover. And in that case, it was held that pursuant to Section 4 of the Act, it was not illegal to publish anything which has, and the court said, an serious artistic purpose. Now, it really does seem that as a result of that case, it's going to be very difficult to prevent the display of or publication of any work of art which has a serious artistic purpose. The Indecent Displays Control Act, it's principally concerned with how public the display is. The concern here is about uncontrolled displays visible to the general public without warning. The act emerged following a case brought against the artist John Gibson, who displayed an artwork containing the dried remains of two real human fetuses in a gallery window in central London. Now, in that case, the work was held to be obscene pursuant to the common law offence of outraging public decency. But the case was important because it established that the test for obscenity was an objective one to be judged against the prevailing standards of contemporary public decency. So that means that as societal moral standards change, so too will the definition of what is considered to be obscene by the courts. It also defined public display as anything capable of being seen by two or more persons. As a result of this concentration on the public nature of display, museum and gallery display was specifically exempted from the Indecent Displays Control Act, where displays visible only to those inside a premises were protected in order to secure that freedom of expression, which really was seen as being so important. I think as a result of current prevailing moral standards here in the UK and the fact that in most cases artworks will be displayed within a gallery, it's unlikely we're going to see many successful claims for obscenity in this jurisdiction going forward. An extreme example has been the repeated display of Marcus Harvey's portrait of the Moors murderer Myra Hindley, which is composed of a mosaic of pictures of children. Repeated attempts to bring proceedings against galleries who have displayed it since it was unveiled at the Young British Artists' infamous Sensation exhibition at the Royal Academy in 1997 have all failed on the grounds that the image may be morally provocative, but it is not indecent, having regard to prevailing moral standards. And also, it was generally displayed within a closed gallery space. Things may be different in the United States, though, and I imagine at the moment this is probably a hot topic of conversation there.
I'm not sure I'm going to get exactly into that, but what I will say is that there's an entire body of law that really relates to. So we have the First Amendment as a part of the Bill of Rights, as a part of the Constitution, and that the concept of the freedom of expression is a very very vibrant and it's a concept woven into quite literally the fabric of our nation. But it's not absolute, and so there are time, place, and manner restrictions that can be placed, and certainly the course of U.S. history has for sure included obscenity restrictions and commerce restrictions on the transfer of that, or the showing of that, or the public showing, or the possession of that, and certainly those are the marks of restrictions on. It is not, that the freedom of expression of all in all ways is certainly not absolute. And I could go so far further on that, but I think that I'll leave it there for that topic.
Yes, and I think we should probably also not underestimate let's say, the commercial appeal that a campaign of outrage might have. I mean,
Mm.
when we consider the poster or one of the posters for the Sensation exhibition was in itself very provocative. A woman with an iron in her hand, and as if to lick the iron, the hot iron. So it's, the kind of outrage, or even for many people, that was very deeply felt, that this was a violation of decency. Nonetheless, also had the appeal of, let's go and see what this is all about. So, but I think maybe a bigger problem now, today, for lawyers, for art lawyers, than questions of freedom of expression is probably the fact that courts are tightening up on copyright, Steve. And I think this is an issue we've already mentioned, this particularly for AI and digital art. Can we talk about copyright and the notion of reasonable use, fair use, I think is the US expression, and fair dealing in the UK? If you both want to take this on, and perhaps we can discuss this over this image here, this image that you've
Sure.
already mentioned, Richard Price.
Yeah. Yeah. So
French,
so
rather.
um, So fascinating issue, and in just sort of by way of background, I believe it was 2013, there was a case involving the artist Richard Prince, who is provocative and likes to, and what his art it does is it takes images of some way, and then it changes or modifies in some way that image for his artistic purpose. And he's gotten himself into a number of different cases that over the years. But so in 2013, the issue was there was a series of photos that I think the photographer, his last name is Cariou, had, and they were of Rastafarians, I think, in Jamaica.
Mhm.
And what the artist Richard Prince did was he superimposed collages and other sort of modifications to those images, same images, but just his own modifications of those. And the court, there was a lawsuit brought, and when it came up to a court decision, and even on appeal, the Second Circuit Court of Appeals on the East Coast of the U.S. Ruled that was what he did was a transformative use
Mm.
of those Rastafarian images, and it created a big stir. There were a lot of lawyers, a lot of commentators that were very critical of that decision, because essentially he was selling it for enormous amounts of money,
Mm.
and essentially taking a series of photos that someone else had, that was their work and their copyright
Yeah.
effectively, and then transforming that. In 2024, that world shifted. And I should say in 2023, the world shifted in that sense, with a U.S. Supreme Court case called about the artist Andy Warhol. And Warhol, long deceased, but back some years back, there was an issue of the magazine Vanity Fair had licensed a picture of the artist Prince, not Richard Prince, but the artist formerly known as Prince, I will say, for anyone in our generation. And to skip to the end of that, because I really do want to get into the new portraits case that you have showing, the U.S. Supreme Court really truly reined in the idea of fair use, and essentially said that especially for commercial purposes, if you're selling artwork. And in that situation, Warhol had done a number of his famous screen prints of this famous portrait of the artist Prince, and then it was sold again in a later time, and then there was a by, I think, the Gagosian Gallery, and that was maybe possibly I'm getting that wrong. It possibly is not the Gagosian Gallery. That's this case, but in any event, and I don't want to say something that's not true. But in the Warhol decision, the U.S. Supreme Court reined in fair use in a way that was dramatic. In 2024, this case, now you're showing this picture where this is a picture that was taken of the musician Kim Gordon, and what the artist Richard Prince did with this picture and a series of other pictures was essentially take that and superimpose it on what we know as an Instagram kind of feed look. So with a username from an Instagram look, and then comments and changing the portrait just in a minor way, but superimposing that with his own sort of commentary on it. And I say commentary in quotes because they're not political commentary. It's not modifying it. It's just simply superimposing it in an Instagram way. And in that case, a judge in the Southern District of New York, Sidney Stern, issued a final judgment basically saying that he was prohibited from, and the gallery that was the Gagosian Gallery was prohibited from reproducing, displaying, or selling those specific works, and ordered a substantial sum of damages. And I think that they ended up settling for an amount, a fairly large amount. I think you have about $900,000 that they were ordered to pay. I think that the settlement was at some amount less than that. But there was a very, very big difference in the way of looking at that and the analysis of U.S. copyright law, and in the fair use, certainly Richard Prince used the fair use defense, and the court basically said that it was being sold in commerce. It was not modified in the image itself. The meaning wasn't modified, and changed, that really expanded what the U.S. Supreme Court really had done even the year before. And that is now a very big difference from what had gone before about the idea of fair use and what artists could do and could not do.
Absolutely. And what I actually found really interesting about that case was that the court actually specifically rejected something which I found was a bizarre defense, but apparently previously had been thought to be good law, which was what I think they called the fame defense, which basically argued that because Prince was so famous, anything he created would be considered to be a new work of art, and that to consider it otherwise would actually have a chilling effect on the entire art market and prevent new people entering the market because they'd be afraid to enter it. I found that argument really quite strange, and the fact that had been considered good law previously, a really odd concept that because someone is a famous artist, regardless of what they create, it is an original work of art. I found that a really strange defense, and I do know that afterwards, reading a few of the kind of commentaries on this case, that was one of the things that a lot of commentators were actually very worried about, was the kind of abolition of this fame defense going forward, which they really did think was going to have a massive chilling effect on artists like Richard Prince producing new work.
Absolutely. There is a corollary in U.S. law and it touches on a different issue, but the Visual Artists' Rights Act um, uh, does it applies some rights to artists, and particularly when there is and the quote is a recognized stature. And that may be where the court was getting that from, and maybe that may be different, but I think that concept of what is a recognized stature, and experts and the art market and so forth would comment on that. But I agree with you that would otherwise be chilling to artists that didn't achieve a either under VARA recognized stature or a level of quote fame of fame that had existed. And I similarly scoff at the fame defense in that case.
It's fascinating, these overlapping areas of, we might say, ethics, common sense, the law, really interesting philosophical questions there for our students to ponder as well, to write essays about. And presumably in both the UK and the US system, these cases, these significant cases then become kind of precedent. Uh, and are
Absolutely.
then
Once they set out a principle, that is it considered to be part of the law. Certainly in all common law systems, if one of the higher courts makes a decision, it becomes automatically part of the law. Interesting, actually, from a UK perspective, generally we're a bit behind the US in matters like this. Now, in the UK, we don't have this. We have a fair dealing defence, and fair dealing is defined by statute, so it's much narrower than the fair use defense in the US. It covers things like using images for criticism or review, for news reporting, or for educational purposes. So it's a very limited list of things you can use them for. Had you had a case like the Richard Prince case arise in the UK, I think what you would have actually seen would have been the person who created the second work of art desperately trying to argue that what they had created was an original work of art. And actually, the test for originality in the UK currently seems to be very wide indeed. For instance, taking a photograph of an engraving has in the past been held to create a new work of art, which is itself subject to copyright and does not violate the copyright of the maker of the engraving. All you needed to show was that some labor was required to create the second work, even if you're taking a photograph of a first work. And the justification for that in terms of photography was that when you're taking a photograph of another work, you have to kind of think about lighting, you have to think about angle, you have to think about the equipment you're using to take the photograph. All of that labor was considered sufficient to make a photograph of another work of art an original work of art in itself. So had that Prince case been raised in the United Kingdom, that's probably the defense that would have been raised, that what had been created was actually a second original work of art, which has nothing to do with the first one. Now, it's interesting. The reason that came into my head when you raised this idea of precedent is that in 2011, we had a very famous case here in the UK called Temple Island Collections against New English Teas. Now, Temple Island Collections is one of these sort of horrible souvenir shops that you find all over London. And they had basically put up an advertising poster for their shop in the window, which is now a kind of ubiquitous black and white photograph of the Houses of Parliament with a red bus picked out in red in front of it. So they created that. Then a tea company, the defendants in that case, decided they wanted to create something similar. So they sent their photographer out, and he managed to catch a red bus crossing Westminster Bridge, completely different angle from the original picture. He took the picture himself. And under those circumstances, you would have thought that the idea of originality was fulfilled there. It was a separate photographer. He'd had to go and put himself in a different position. He'd had to think about lighting. He'd had to wait until this bus actually started coming across the bridge. You would have thought that second image would have been protected. However, in those circumstances, the court held that they had actually breached copyright. Now, you're saying this thing about precedent. In general, had that been a decision of the Court of Appeal, that would have been the law going forward. However, it was not. It was a decision of the county court. It is therefore arguable that that decision is actually wrong, and it will be very interesting to see what happens to that decision afterwards, because if that decision were to be followed in a higher court, that is very considerably limiting the originality defense in English law. It's basically saying that, even though you've gone out and taken a completely separate photograph, because the idea behind it is the same, that is enough to trigger copyright. And that has never formed part of English law. This idea that you can protect an idea. You can only protect the expression of an idea and not the idea itself. It will be interesting to see what happens to that. And I do have to say, you know, when you read the facts of that case, I think what really persuaded the court in this particular case was that the tea company, the representative of the tea company, utterly bizarrely, just openly admitted that he had copied the original image. He came into court and went, yeah, I saw that poster and I thought I'd like to create something like that. And I went out and tried to recreate it. And I think without that very blatant and patent admission of copying, I don't think that decision would have been made. And it will be very interesting to see if one of these issues comes before a higher court, whether they follow it or not. Now, the reason that nothing has come up between 2011 and now, this is another thing to be aware of with copyright. Very few of these cases actually make it to court. So if you are a practitioner within the art market or the heritage kind of market, you will very rarely go to court on a copyright issue. You will, of course, write to the person who has breached your copyright and tell them they breached your copyright. And you will then generally either be happy when they take the image down, or you'll be happy when they give you a big lump sum to pay you not to go to court. Very few of these cases actually make it to court in the UK. And that's why we have this weird 2011 lower court case that's still causing anxiety among practitioners because they don't know how a higher court as yet is going to react to it.
I just want to say a point about precedent, and you asked the question that kind of related to precedent, and I think that in any situation in the law, you can look at what precedent is, but the principle may exist in that case, but the facts are different. And so what skilled litigators, you know, and practitioners do is to try to use the facts of that particular case, either to distinguish your set of facts or to apply that set of facts. And so when you say precedent, you have to be careful about what that means, because particularly as we've talked about in the first recorded session, when we were talking about the uniqueness of art and the sort of the boundary pushing and all of those different things, that is of real significance when you talk about precedent, because those facts, so for example, one fact that they looked at in the Warhol case, in the US Supreme Court Warhol case, was that it was commercially sold, right? But it wasn't exhibited, it wasn't, you know, and so like those are particular facts that you look at and you can try to distinguish as a practitioner. And I think to bring it back to the concept of what an art lawyer does, it's taking your set of facts and looking at what the case law says and statutes and regulations, and then fashioning an argument that makes, you know, emotional sense, legal sense, practical sense, and common law sense.
Absolutely, and that's exactly what I was saying. I imagine if that red buses case ever does come up again or something similar to it, you will find that there will be pled that what decided that case was the fact that the defendant had admitted copying, and that very rarely happens. In fact, it never happens that a defendant turns up in court having got as far as court and then basically say, yeah, we're guilty, sorry. That very rarely happens, and I imagine that case will be restricted to the fact that the defendant actually admitted the copying there.
And you mentioned copyright before, and of course, if we now move on to not just the responsibilities and duties the artist has, but also the rights that they have. So copyright is one. You mentioned that it's not often, at least in the UK, not often enforced in courts. There's also moral rights and artists' resale rights. Could you both talk a little bit about this? Steve, maybe if you start.
Sure. Yeah. So in particular, with respect to moral rights, and I've touched on the Visual Artists' Rights Act. It's essentially a set of statutes that relate to what protections an artist has in preventing either unfinished work or destruction of work in some way. And there's a particular case study that I want to talk about in a moment. But it has a set of, it's the best version that the U.S. could come up with really that relates to the concept that I think the UK and the EU have a little bit more in place of this concept of moral rights of artists. And the case that I want to bring up is this 5 points case, points with a Z, and it was I believe it was in I can't remember whether it was in Brooklyn or Queens, but in New York City, there was a warehouse essentially, and over time, the warehouse existed. The warehouse was owned by an owner, and over time, artists, graffiti artists, had used one of the largest walls of this warehouse to start doing graffiti art on it. And it became a thing. It became something where people wanted to go and see the artist's work and it drew some of the best graffiti artists at the time. And people would, it was an honor to be able to kind of put their stamp on that. What was interesting was that there was the owner. And I can't remember whether there was a change of ownership or the owner wanted to then develop it and basically tear it down and develop it into high-rise buildings. And there was a moment where a court it declined to impose a preliminary injunction or a temporary restraining order to say that the building owner could not take it down. And the court declined to order that temporary restraining order. The building owner immediately whitewashed over the graffiti and essentially effectively destroying all the graffiti art. And it ended up over a course of several years and in a course of several different sort of iterations of that case, ended up with an enormous award that was then upheld in favor of the artists and against the owner of that building. And it was based on the right of this Visual Artists' Rights Act in VARA. And I think that was a huge. VARA was this statute that existed that hadn't been tested, hadn't been used in a very dramatic way, and that opened everybody in the art community really started to understand about the power that VARA could have in particular application. Kyle?
Absolutely. And if I take over from there, then just in relation to the UK, I mean, it really does have to be said that moral rights and this idea of moral rights in artwork, it's very much a creature of the civil law of Europe rather than the common law as it applies here in the UK or indeed in the US. I mean, this idea of moral rights really is derived very much from the philosophical thinking of people like John Locke and Immanuel Kant, who kind of viewed works of arts as an emanation of the personality of the creator. So they would have believed that the creation of artistic works creates a number of perpetual rights vested in the artist and their family successors, which can be enforced by the courts. They could not be sold on to anyone else, and they remained either with the artist during their lifetime or the artist's kind of successors afterwards. The English and American common law tends to be much more practically focused. We don't tend to rely on philosophers to come up with great ideas of what our law should be. We generally react to real situations with real solutions. We're much more practically focused, and therefore art, as we said in our first video, was viewed as just another form of craftsmanship, producing a commercial asset. So once sold, the rights of the creator and their successors in title was very much terminated. However, moral rights formed a central part of the Berne Convention for the Protection of Literary and Artistic Works of 1886. And as a signatory to that convention, they were introduced for the first time really into English law. As a result, they now set out within Chapter 4 of the Copyright Act a series of moral rights derived from what was set out in the Berne Convention. They include artist resale rights, whereby artists and their successors will receive a proportion of the proceeds of the resale of the works for the duration of the artist's life and for 70 years after their death. There's also a right of paternity, so a right to be recognized as the artist of a particular work. And a right of integrity, which is what Steve was dealing with there, a right whereby your artwork cannot be displayed in a way which undermines either the reputation of the artwork or that of the artist. And that right has actually been quite powerful and has come up quite a few times in the English courts.
I will say that so California, the great state of California, actually tried to enact and not just tried to, but enacted a law that provided for resale rights for and royalties for artists. It was then preempted, what's called preempted by the federal law and that I described of the Visual Artists' Rights Act. And so it really had, I think it had an application for a very short period of time, like something like a year, but that was about it. And otherwise, that's not of real legal moment. I would say, but there was an attempt to, and there are, and that is a continuing discussion about whether to have artist resale rights generally in the U.S. other than by contract. And I will say that there are certainly contractual rights that both galleries and artists can have as their terms that can restrict that. But it's simply the violation of that would be a breach of contract and in a civil suit. And so there are limits that you can place on it, but it's not other than VARA, it's not a vibrant area of law at this time in the U.S.
And I think, the influence of the EU in the UK as well has meant that this is probably much more of a vibrant area, and people certainly are much more aware of it here. But as you say, it's a strange kind of adaptation of the rights of property, because generally, if you own something and you sell it to someone else, that's it. So the idea that these perpetual rights would emerge is very alien, I think, to the common law. And had it not been for the Berne Convention and our membership of the EU, I don't think these things would have been as strong in the UK either. But currently, they are quite strong.
Fascinating. I think we should take a break here before we get to our last point when we consider when we move from the artist to the artwork in the widest sense. Thank you very much.